Now another developing story we're following.
I can't say I'm excited by this ruling. I wish I was never here. But what we've said from the outset is, all we want is our day in court.
And now the families will potentially get their day in court. Today, the Connecticut Supreme Court narrowly overturned a lower court's ruling.
Family members of these 9 people who lost their lives in Sandy Hook filed the wrongful death suit. Today's ruling means they can sue the company that made the guns used to murder their loved ones. Channel 3 New Haven Bureau Chief Matt McFarland is live now with more on today's ruling and reaction.
Well, Dennis and Denise, just how close was it? It was a 4-3 split decision. Now, a 2005 federal law prohibits gun manufacturers from being sued if the case is where a gun of theirs is used in a crime. But the justices of the majority said Remington could be sued under a Connecticut state law for alleged wrongful marketing.
This is nowhere where we want it to be. But that being said, I'll spend the rest of my life in this particular avenue in one way, shape, or form.
Bill Sherlock, whose wife Mary, the school psychologist, was killed at Sandy Hook, is part of a wrongful death lawsuit against gunmaker Remington that's now getting a second chance.
The good that ought to immediately come out of this case is to cause a day of reckoning in the boardrooms of gun industries across the country, so that instead of focusing on how do we sell the most weapons to the most people, maybe they can start focusing on how do we reduce the risk to the public.
The families and their attorney allege Remington glorified the AR-15 style rifle through its marketing, while Connecticut Supreme Court agreed with the lower court's ruling, dismissing most of the family's claims while challenging a federal law shielding gun companies from lawsuits. 4 justices ruled it would allow the wrongful death lawsuit to move forward based on a state law regarding unfair trade practices. Quote, "As we have stated throughout this opinion, we do not know whether the plaintiffs will be able to prove these allegations to a jury, but we are confident that this sort of specific, narrowly framed, wrongful marketing claim alleges precisely the sort of illegal conduct that Congress did not intend to immunize." Writing for the minority, Chief Justice Richard Robinson didn't see it that way. Quote, "I conclude, therefore, that the Arms Act preempts the plaintiff's claims of immoral advertising. I therefore respectfully disagree with Part 5 of the majority's opinion, and I would affirm the judgment of the trial court in its entirety. Accordingly, I respectfully dissent."
What went on inside? What went on inside Remington? Let's see the internal documents, the internal emails as to what the charges were to their marketing and ad execs. Who is it we're trying to target?
Now, we did reach out to the attorney representing Remington for a comment. He did not respond. We're live with the mobile newsroom. Matt McFarland, Channel 3 Eyewitness News.